Laura Diaz.
Great, we'll call the state of Wisconsin versus Laura Diaz. It's 25 CM 2987 appearances.
ADA Cecilia DeMarco for the state.
Attorney Emily Bell appears on behalf of Laura Diaz, who appears along with me. Good afternoon, Your Honor.
Good afternoon. Do you have a copy of the criminal complaint?
I do. We would waive reading, stand mute, and ask the court to enter a not guilty plea on Ms. Diaz's behalf.
Right, I don't think there's a public safety assessment. I'll find probable cause for the charge, enter a not guilty plea. And I was informed we may have a victim who wanted to make a statement. If that person is on Zoom, you just need to unmute. All right, I think that person is unmuted. If
Yes,
you could
sir.
just identify yourself for our court reporter.
Anthony Diaz.
Okay, and what did you want to say?
I would like to ask for a contact. So to go away from the no contact. Our daughter has a serious complex medical condition, and we really need to be able to communicate. That's really important to, I think, both of us. I do also want to make sure that there's no alcohol involved in this, and we go from there. I'm not sure what else to say.
Okay, thank you, Mr. Diaz. And what's the state's position on bail?
The state respectfully disagrees with the victim's position. We are recommending a signature bond. Oh, no, I'm sorry. I read that incorrectly. The state is recommending a signature bond. The state would be willing to recommend no acts or threats of violence towards the victim and would ask that a no alcohol condition be ordered as well, echoing the victim's concerns with that respect.
All right, any objections?
Yeah, no, we have no objections to that.
All right, we'll order a signature bond. Condition will be that you direct no acts or threats of violence towards Anthony D. and that you not possess or consume any alcohol. The clerk indicated that the 72-hour no contact was enforced. That's still in place until tomorrow at 11:06 p.m. So you're not going to be able to go back there unless you're in the presence of law enforcement. You can go one time with law enforcement if you're able to arrange that. Otherwise, you can't have contact with the victim or be at the residence. You'll be in violation of the no contact. You can get charged with a misdemeanor for that and charged with bail jumping. That said, given Mr. Diaz's position, if that's something that he wants dropped, that's not something I can do here today, but you can reach out to the law enforcement agency that made the arrest and let them know that. But until you're absolutely 100% sure that's dropped, you don't want to be having contact before 11:06 tomorrow. Understood? All right.
She indicates yes.
Very good. We'll be adjourned if there's nothing else.
All right. Thank you, Your Honor.
John Wallace. Wallace.
We'll call the state of Wisconsin versus Dion Wallace II. It's 25 CM 2978 appearances.
ADA Cecilia DeMarco for the state.
Dion Wallace appears in person and in custody with Attorney Devontae Wyndham for the State Public Defender's Office. Mr. Wallace is not eligible for public defender services. I'm handing him a copy of the public defender sheet in case he wishes to reapply. In addition to that, we have an updated address. The address on the complaint is incorrect. The best address for him to receive mail is 2860 East Washington, apartment number 518 53704.
All right, and Mr. Wallace, you're entitled to an attorney. If you can't hire one after today, your options are to apply for a county attorney. That's the middle option, or you can reapply with the public defender's office. We'll make findings of probable cause and are not guilty pleas to the charges. There's no PSA report. State's position on bail.
The state is recommending a signature bond. We are asking as the sole condition, the defendant have no contact with Giuliana, JILANNA, last initial L.
Any objections?
We have no objection at this time, Your Honor.
Your character fan appears to be spelled JIANNA. Go up. Please start inside an L is on the left.
All right. Well, if there's no objection from the state, we'll use that spelling, and it looks like that's probably how it's spelled. Maybe there was a typo on your bail notes.
I'm not sure. I'm just going off of how it was entered in Protect.
All right, and to clarify, is the no contact going to cause an issue with the updated address?
I don't believe so.
No.
All right. Okay, I just wanted to make sure that you weren't gonna be running afoul of the bail conditions and going back to that 2860 East Wash address and having contact with the victim and getting in trouble with a bail jump or anything. So order a signature bond, condition will be a no contact direct or indirect with Gianna L, and we'll be adjourned.
Next is William Carter. Carter.
All right, how are you, Mr. Carter?
Great, we'll call the state of Wisconsin versus William Carter. Those are case numbers 25 CF 2704, 25 CF 2872, and 25 CM 1874 appearances.
ADA Cecilia DeMarco for the state.
William Carter appears in person, in custody, and with Attorney Devontae Wyndham from the State Public Defender's Office. Your Honor, we've acknowledged receipt of the complaints. We'll waive their formal reading, standing mute to any misdemeanor charges. The address on the complaint appears to be correct.
Right, so probable cause has been found in each of the cases already, except for 25 CF 2872. I'll find probable cause there. We'll enter not guilty pleas to the charges. I don't think there's a public safety assessment report for any of these cases. And I believe we have a victim in 25 CF 2704 who wanted to make a statement. If we've got that person on Zoom, they just need to identify themselves and then let us know what their position is on bail or bond conditions.
Yes, thank you, Your Honor. My name is Marie Neon, and Your Honor, I have something I would like for the court to know. I would like, if possible, to consider allowing contact between the defendant and I, and to drop any charges regarding this case. We do live together, and at times I've only depended on hope and prayer, and he's been there for me and still continues to be there for me. Thank you, Your Honor.
Okay, thank you, Ms. Neon. And it looks like the name is spelled Marie, M-A-R-I-E, Neon, N-I-A-N-E. Is that correct?
That's correct, Your Honor.
All right, thank you. What's the state's position on bail?
Thank you. So with respect to each of these matters, I'll begin with 25 CF 2872. In that case, the state is recommending that the court set cash bail in the amount of $3,000 with conditions that the defendant not operate any motor vehicle, not use or consume any alcohol during the pendency of the case, not use or possess any controlled substances or drug paraphernalia without a valid prescription, and that he be subject to pretrial services to monitor alcohol and any drug use, if the court is willing to consider that. In that case, the factual basis is quite concerning. It's alleged the defendant fled from officers traveling at speeds of up to 90 miles per hour on city streets. that at one point started at him being clocked around 55 miles per hour in a 25-mile-per-hour zone, which is concerning in and of itself, but it's clear that allegedly the high rates of speed did not stop there. He's alleged to have made admissions of both drinking and taking drugs and was also in warrant status for a pending operating while intoxicated as well as a felony battery case when this took place. In 25 CF 2704, the state is asking for the court to impose an additional $1,000 cash bail with conditions that the defendant have no contact with Marie and not be at any residence that she is living at or place she temporarily occupies. In 25 CM 1874, we're asking for an additional $300 cash bail with conditions that the defendant be prohibited from operating a motor vehicle, that he not use or consume any alcohol during the pendency of the case, that he not use or possess any controlled substances or drug paraphernalia without a valid prescription, and that the court consider adding a pretrial services condition to monitor any substance use if applicable, if the court finds it is appropriate in the earlier case that I mentioned. As far as the non-monetary conditions go, obviously, whether or not the defendant is allowed to have contact with Marie N is at issue here. I don't wish to disrespect her position, but I do have to respectfully disagree. What's alleged in that case is a extremely violent and prolonged attack that's alleged to have taken place in public during the day while the defendant was wanted for a warrant based on a failure to appear in the 25 CM matter after he did not make his court date on October 2nd, 2025. I can add more information if the court would like. Otherwise, I'll turn it over to defense.
Sure. If there's anything else that you want to say, we might as well hear that, and then Attorney Wyndham can respond to all of it.
It's my understanding that the defendant does have a prior violent conviction from 2017 where he was convicted of domestic battery. As far as prior cases beyond that, it looks like this is the first referral between the parties as far as Marie N being one of the victims. But I do note that prior domestic history, not to belabor the point, but because that is a Act 3 consideration and the case involving Marie N is something that qualifies for an Act 3 case. It looks like the defendant was revoked from probation in that case I just mentioned, which is Dane County case number 16 CM 342. It involved a different woman as the victim. He was convicted on February 7th of 2017 and revoked from probation a few years later.
Great. And Attorney Wyndham?
Yes, Your Honor, we'd be seeking a more modest amount of cash bail across the three cases. And I'll also address the non-monetary conditions here. I don't think pretrial services is warranted at this point in time, given the nature of these cases and the limited resources that pretrial services has. In regards to the circumstances here, I do believe that the non-monetary conditions of no operation of a motor vehicle and no alcohol or other drugs is an appropriate condition across these three cases. As far as the no contact, I do believe that the alleged victim here is closer to the situation than anyone else is. These incidents are alleged to have occurred here on October 17th, so nearly 2 months ago. In regards to the circumstances, there were no bail conditions, not allowing contact at that point in time. So for the past 2 months, Mr. Carter and the alleged victim here have had opportunities to contact each other, speak with one another, live with one another. And so frankly, there have been no new incidents since that October 17th date. So for all those reasons, I do believe that allowing contact and requiring no acts or threats of violence would be appropriate in that matter. As far as the cash bail, I think a more modest amount of cash would be appropriate. I recognize obviously the failure to appear from the August 5th case operating a motor vehicle while intoxicated. And so I do believe that a more modest amount of cash across these cases would be appropriate. I think $250 across the first OWI and the domestic case would be appropriate, and a bail of $500 on the newest OWI matter I believe that is 2872. I think that would be appropriate. I think that would adequately ensure his appearance in court and also be a significant amount of cash to comply with bail conditions. Thank you.
All right, well, I think there's a need for cash bail. He had notice, he was provided the citation with the mandatory court date in the misdemeanor case, didn't show up. Then we have the fleeing and eluding, and if he's convicted in that OWI third, then he's looking at a felony OWI fourth in that case, along with the eluding charges. And then we've got a felony domestic case. All of that, I think, warrants some cash bail to assure appearance in court. I think the state's proposed numbers are pretty spot on. I'm going to adopt the cash bails that are requested. In 25 CF 2704, I'll set $1,000 cash bail. I'm going to order a no acts or threats of violence with Marie N. As noted, the incident happened several months ago. There haven't been any other prior instances. There's not a prior history here. I understand another domestic that's somewhat dated. I think that more goes to the Act 3 analysis and the cash bail than requiring a no contact with the victim given her express wishes. So it'll just be a no acts or threats there. In 25 CF 2872, I'm going to set $3,000 cash bail. I am going to make a referral to pretrial services. I'm concerned we pick up an OWI third, then we have an OWI fourth where he's doing 90 miles an hour, fleeing, eluding from law enforcement. That's extremely dangerous conduct. I think we need to monitor his alcohol and drug use. So if you do post, you're going to have to report to pretrial services no later than 10 a.m. on the business day following your release. The deputy is going to give you the map to their office, but they're on the 5th floor of the Dane County Courthouse. I'm going to ask that they test you for controlled substances and test you for alcohol use. They'll decide whether they're using a breathalyzer or a bracelet to test the alcohol. In 25 CM 1874, I'm ordering $300 cash bail, same non-monetary conditions as the other felony, pretrial services, not operate a motor vehicle, not use or possess alcohol, not use or possess controlled substances, and that should be tested for alcohol and controlled substances by pretrial services. I think if we're using it in the felony case, we might as well use it in the other one where there's issues with that. I don't think that really causes any additional work for their office, so I think it's appropriate in both cases. What about time limits for the preliminary hearing?
We'd ask for a timely prelim.
Okay, we'll get that scheduled and we'll be adjourned.
Yeah.
Next is Gregory Lamb, hearing via Zoom.
Wait just a minute.
That's the actually for more. I want this out. It was just so loud. I was like, you went off.
Yeah. Oh, yeah, all right.
All right, we'll go on the record in the state of Wisconsin versus Gregory Lamb, 25 CM 2974 appearances.
EDA Cecilia DeMarco for the state.
Mr. Lamb, can you hear me okay?
I think he's muted.
I-
Can you
I
get the
can hear
thumbs
you,
up?
sir.
All right, there we
Hey,
go.
Mr. Lamb, you indicated that you did not want SPD to represent you in regards to this case. I'm here from the public defender's office to help you out with bail in this situation. If you want me to, I can represent you at this hearing and this hearing alone. But that's up to you.
Up to me?
Yep.
Well, in my issue, I done talked with my agents and everything, you know what I'm saying? My system is clean. I don't, you know what I'm saying? These are false allegations.
Okay, so Mr. Lamb, the question is, do you want Attorney Wyndham, who's an experienced attorney, to help you here
Yes, yes,
today?
yes.
Okay,
You know,
sure.
I'll go
He'll do
along.
that.
I'll go along.
Yeah,
You know.
yeah, he'll do that.
So Mr. Lamb appears in person, via video and with Attorney Devontae Wyndham from the State Public Defender's Office. We're unaware at this time if Mr. Lamb is eligible for public defender services. We'll acknowledge receipt of the complaint, we'll waive its formal reading and stand mute to the charge.
All right, I'll make a finding of probable cause. There's a public safety assessment report. It recommends moderate cash bail. Looks like there was a DOC hold that's since been dropped. And Mr. Lamb, you do have the right to an attorney, and after today, if you want an attorney and can't hire one, you can always apply with the public defender's office, and I'll ask that the bailiffs give you that information. What's the state's position on bail?
Thank you. The state is willing to recommend a signature bond given the DOC hold. We are asking that as conditions, the defendant be banned from Sonnet Memory Care, SONNETT. That's located within the 1900 block of Tennyson, TENNYSON Lane in Madison, and that he have no contact with Crystal G as in goat.
Great. Any objections, Attorney Wyndham?
No.
All right, we'll order a signature bond, condition will be a ban from Sonnet Memory Care on Tennyson Lane, and that you have no contact, direct or indirect, with Crystal G. If we could unmute deputy, I'm not sure we have a good mailing address for Mr. Lamb, is there?
Yeah, I have
place
an
we can-
address. I have, yeah, 510
Okay, can you,
517 East Washington. That's my, you know, I have placement.
the Beacon?
No, I'm with OR program. I have my own place.
516 East Wash?
Yes, sir. Yes, sir. Washington, East Wash. Yeah,
Okay.
517, yeah, apartment 135.
Apartment 135? Okay,
Yes.
thank you.
Yes,
And
please.
Number 516, East Wash.
Mr. Lamb, 516 East Wash, apartment 135?
Yeah.
517.
517, yeah.
517.
517, yeah. Either case,
517.
yeah, my case.
Okay. All right, we'll get the address updated, and I think you're gonna get released yet today, okay? We're adjourned.
Next is Jeffrey Davis.
Davis?
We'll go on the record in the state of Wisconsin versus Jeffrey Davis III. It's 25 CF 2860 and appearances.
ADA Cecilia DeMarco for the state.
Jeffrey Davis appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Davis is eligible for public defender services. The best address for him to receive mail was probably the Dane County Jail at this point in time. And we'll acknowledge receipt of the complaint and waive its formal reading.
Okay, and it's fine to use the jail. Looks like there's a DOC hold that's still in place, but if that's dropped and you are released, just let your lawyer know where you want your mail sent so you don't miss any future court dates. We'll make a finding of probable cause, and there's no PSA report because he's been in on the hold. State's position on bail.
Given that this case is an Act 3 eligible offense, the state is going to recommend cash bail. We're asking that you set that at $2,500 with conditions that the defendant be banned from Easttown Mall, banned from all Dick's Sporting Goods locations, that he have no contact with Jacob, common spelling, last initial M as in mother, and that he be prohibited from using or possessing any dangerous or facsimile weapons as defined by Wisconsin statutes.
Right, and any additional argument you want to make on the cash bail? Do we know what he's on supervision for or what his prior criminal record is?
I believe he is on supervision for theft from person offense, which is a felony.
Right, and Attorney Wyndham?
Yes, we'd be seeking a more modest amount of cash bail. We'd have no objection to the non-monetary conditions. We think those are appropriate. However, we think a more modest amount of cash bail in the amount of $500 to $1,000 would be appropriate. Mr. Davis is a lifelong resident here in Dane County. He has parents, siblings, and extended family and friends that all reside within the community. Most recently, he was taking care of his grandmother. And so for those reasons, given the ties and things along those lines, I think a more modest amount of cash would be appropriate. I understand this is an Act 3 eligible case, but we didn't hear any reference to any missed court appearances. There's obviously criminal convictions, but there hasn't been any reference to any missed court appearances. So for those reasons, I do believe that a more modest amount of cash would be appropriate. Thank you.
Right, and any response from the state?
Sure. So I don't see any history of missed court appearances based on the information I have available in Dane County. But what does concern me a bit more is that the defendant was placed on probation for that theft from person offense that I mentioned, as well as I believe a felony bail jumping. And that was just in October of this year. So the proximity of that resolution to the allegations here does not bode well, and I think does strengthen the state's argument.
All right, well, it's an Act 3 eligible offense. I'm supposed to take into account whether cash is necessary to protect the public. I think there's a pretty compelling argument here. We've got somebody who is on supervision for something pretty close to a robbery, but he's now allegedly escalating with a facsimile weapon that the victim thought was a real gun. And I understand the concern they would have had when they saw I think it was a airsoft gun, thinking that it's real. So supervision wasn't sufficient enough. Mr. Davis has also apparently violated conditions of bail in the past. All of that suggests that cash is necessary, and just simple court orders is not sufficient to protect the public. And when I'm at that conclusion, I don't think modest amounts of cash bail are sufficient to do that. I think the state's request is warranted and necessary. I'll set $2,500 cash bail. Order a ban from Easttown Mall, a ban from all Dick's Sporting Goods, that you not use or possess dangerous weapons as that's defined by the statutes, or any facsimile firearms, and have a no contact director and directed Jacob M. We can set a prelim in the next 10 days if you'd like, Attorney Wyndham.
Please do.
Okay, we'll get that scheduled and we'll be adjourned. Appreciate it.
Sorry, what was that bail amount?
$2,500.
First name was Christopher Coffey.
Yeah.
That's what I thought. My brain shut off for a second. Yeah. That's what I heard.
Coffee. All right, we'll go on the record in the state of Wisconsin versus Christopher Coffey. It's 25 CF 2867, and we also have a bail hearing in 25 CF 1311 appearances.
ADA Cecilia DeMarco for the state.
Christopher Coffey appears in person and in custody, and with Attorney Devontae Wyndham from the State Public Defender's Office. Ms. Coffey is eligible for public defender services. Will acknowledge receipt of the complaint and waive its formal reading. Standing mute to the misdemeanor charge.
All right, looks like he failed to appear on November 17th in 25 CF 1311. I'll make a finding of probable cause for the new case, and or not guilty plea to the misdemeanor. And I don't believe we have a PSA report. What's the state's position on bail?
Thank you. So for the case, we're here to address bail on, which would be the CF matter. We're asking the court set cash bail at $500 with the same conditions previously ordered, seeing as a signature bond was not sufficient to deter missed court appearance that was previously referenced. In the case that is here for initial appearance, which I believe is, sorry, also a felony matter, that is 25 CF 2867. In that case, we'll ask the court to set $400 cash bail with standard conditions. I don't think any specific conditions are necessary in that matter, but I do think it's relevant overall to mention the facts briefly, as it does add to the state's bail argument. It's alleged that in that matter, the defendant was fleeing on foot from officers due to the knowledge that he had an active bench warrant. So I do think that's relevant to the state's argument and makes the state's recommendation reasonable.
Right, and Attorney Wyndham?
Yes, I would note that Mr. Coffey is eligible for public defender services. We'd be seeking a more modest amount of cash or signature bond here in these matters. These matters here, possessory drug offense, as well as an obstructing an officer and a felony bail jumping, do not scream large amounts of incarceration. These are not Act 3 eligible cases. We recognize that there was a missed court appearance. It's my understanding that Mr. Coffey had a mix up with the court dates. He's a lifelong resident here of Wisconsin. I do believe that a signature bond or a more modest amount of cash would be appropriate here, given the nature of these charges, in the amount of $150 to $300 per case.
All right, so the original public safety assessment in 25 CF 1311 did recommend a signature bond. It did note at least one failure to appear older than 2 years. I don't know when that was or whether there was more than one, but that is significant because this isn't the first miss, and then probably even more significant than that is, instead of turning himself into the jail, he ends up having contact with law enforcement and then is resistive obstructive. To me, that's not consistent with somebody who's going to voluntarily appear. I see these as cash bail cases. I think a slightly more modest amount is sufficient given the nature of the charges. I'll set it at $300 in each case. The prior conditions in 25 CF 1311 will remain the non-monetary conditions, that is, and then it'll just be the statutory ones in the other one. Does he want to prelim in the next 20 days?
Yes.
Okay, we are adjourned.
All right. Saying happy about here. 600 total.
Yeah.
Next is Alman Sotelo, here in Zoom.
Right, we'll call the state of Wisconsin versus Jackson Ailman. It's 25 CF 2858 appearances.
ADA Cecilia DeMarco for the state.
Jackson Ailman appears via Zoom. Mr. Ailman, can you hear us okay?
Give us a thumbs up if you can hear everyone okay, sir.
What did you say?
Can you hear them?
If I can hear, well,
Yeah.
no.
Can you hear me?
Did you hear them?
Okay,
Mr. Ailman, can you hear us? Can you answer out loud?
Yes.
Yes, I can hear
Okay, very good.
Jackson Ailman is eligible for public defender services. We'd acknowledge receipt of the complaint. We'll waive its formal reading. We'll stand mute to counts 2 through 4. And Mr. Ailman, is the best address for you to receive mail 209 East Mifflin?
No, no.
What would be the best address for you to receive mail at?
Well.
So I have a 2953 Fern Drive in Sun Prairie, is that right?
As of right now, I would say. I would say. The Salvation Army on East Washington.
630 East Wash. Okay, we'll update the address. And I'm sorry, did you say if he was eligible?
He is eligible.
All right. We'll make a finding of probable cause and are not guilty pleas to the charges. There's no PSA report. State's position on bail.
State is asking that the court set cash bail in the amount of $2,500. As conditions, we are asking that the defendant be banned from the 400 block of West Gorham Street, as well as the State Street and Langdon area specifically, or more generally, sorry. More specifically, we're asking that that 400 block of West Gorham encompass a specific admonishment that the defendant is banned from the James Apartments. We're asking that he have no contact with the victim whose initials are KMF, and that he be placed on pretrial services for GPS monitoring to impose and monitor those address bans if he is able to post cash bail should the court adopt the state's recommendation. The defendant has had some recent missed court appearances. He had bench warrants issued on July 22nd of this year, January 15th of 2024, as well as January 2nd of 2024. He had cash bail set previously in Dane County case number 25 CM 2614, which was only reduced to my knowledge to a signature bond due to the defendant experiencing a medical emergency in jail and needing to be treated out of custody at Meritor before being released after medical treatment. Based on the fact that he previously had cash bail in his other cases, he's now escalating his behavior. It's alleged here that he attacked a complete stranger and stole from her at a place that he was already previously banned from. As the James indicated, the defendant was known to that residence and he was not supposed to be there. The state believes that cash is necessary to ensure his future appearances, given the increasing exposure as well as the very recent failures to appear that I cited previously.
All right, and just to clarify, that ban was not a condition of bail, just the apartment complex had banned him.
Yes, to my knowledge, the apartment complex had told him previously that he was absolutely not welcome there.
All right, and aside from the pending misdemeanor, is there a prior criminal record?
I would need a moment to investigate that to thoroughly answer the question. It seems that he was convicted in October of lewd and lascivious behavior. I believe with the repeater modifier, that's in Dane County case number 25 CM 1849. He was convicted of misdemeanor battery in 24 CM 2310. 2 counts of misdemeanor battery, actually. That was a conviction entered in August of 2025. He was convicted of misdemeanor theft of property in 23 CM 2690 and was placed on probation in February of 2024, but was later revoked a few months later in September. He was convicted of disorderly conduct in a different case, also in February of 2024, misdemeanor theft, same time, different case. That's the extent of his adult criminal history.
Great, and Attorney Wyndham?
Yeah, we'd be seeking a more modest amount of cash bail here. As far as the circumstances surrounding this case, we'd also ask for a timely prelim. In regards to the circumstances, Mr. Ellman is eligible for public defender services. It's my understanding that he's also eligible on that misdemeanor matter. I believe that part of the issue in regards to some of those missed court appearances is that Mr. Ellman has been waiting for an attorney to be assigned on those matters. Due to his out of custody status, as well as the misdemeanor nature of that case, my office has prioritized people in custody. In regards to the circumstances here, I do believe that him having an attorney will help adequately ensure his appearance in court. He does have ties to the community. It's my understanding that he has resided here majority of his life, if not all of his life. And due to his indigency, shown through his eligibility through the public defender services, I do believe that any amount of cash would essentially be holding him. I think a more modest amount of cash would be appropriate. I do believe that pretrial services is appropriate here and would adequately be able to monitor and help protect the public in regards to those avenues and aspects. So I believe that cash bail in the amount of $1,000 would be appropriate, and the non-monetary conditions that the state has suggested are appropriate as well. Thank you.
All right. Well, I think there's a need for cash bail on the failure to appear analysis, given 3 recent failures to appear, and certainly the nature of the charges are serious. That provides some added incentive not to appear in court. And an Act 3 analysis, I think there's a fairly strong case. I've got somebody who's got 2 prior violent convictions with the misdemeanor batteries. Sounds like a lot of his criminal history is pretty recent, and this is a serious escalation of that. He was already out on bail, and so that certainly wasn't enough to protect the public. If it's true that he committed this offense with a stranger in a violent offense, I think there's a need for cash bail to protect the public. I think the $2,500 is necessary. I'm not going to go below that. I'll order that. I'll order pretrial services if you post to monitor the geographic bans. So you would need to report to pretrial services no later than 10 a.m. on the business day following your release. They're on the 5th floor of the Dane County Courthouse. They will provide you a map to their offices. We'll order a ban from the 400 block of West Gorham Street, and that was specifically the James apartment complex.
Yeah, we would ask that he be banned from the block in its entirety, but also with a specific condition to not be at the James.
All right, so ordered. And then I'll order a State Street Langdon ban per the ban map. And they will provide that to you as well. And a no contact direct or indirect with KMF. Then pretrial services will monitor the address bans with the GPS if you post. What about time limits for the preliminary hearing?
We would ask for a time limit.
Okay, we'll get that set the next 10 days and we'll be adjourned.
Next is Kender Madrid-Barrello.
Grizz? Great, we'll go on the record in the state of Wisconsin versus Kender Madrid-Marrero, 25 CF 2865 appearances.
ADA Cecilia DeMarco for the state.
Kender Madrid-Marrero appears in person and in custody with Attorney Devontae Wyndham from the State Public Defender's Office. He is eligible for public defender services. We'd acknowledge receipt of the complaint. And we'll waive it, or actually, we'd ask that count 1 be read so that he understands.
Okay, and is it sufficient to just have the interpreter read that to him? Or do you want me to read it in English and then the interpreter to interpret it?
I think the interpreter would be fine.
All right, let me swear in the interpreter before that. We have Fred Svensson, the certified Spanish interpreter, and Mr. Svensson, do you swear or affirm that you'll truly, accurately, completely, and partially interpret the proceedings? And also that you will truly and accurately read count 1 and the penalty section to him?
Yes, Your Honor.
Thank you.
Tienes un cargo por el intento a eludir o escaparse de un oficial. Siempre el acusado estado aquí en esta dirección el domingo 14 de diciembre en la ciudad de Preso, intentado de Wisconsin, al liberar un vehículo en una carretera después de recibir un señal audible o visual de un oficial de tránsito, un oficial de ejecución de leyes federales o una patrulla marcada que el operador debería haber tenido entendimiento razonable que era un oficial operado por un oficial, intencionalmente o a sabiendas se fugó o intentó eludir un oficial de tránsito aumentando la velocidad del vehículo, algo que está en contra de sección 346.04 de los estatutos del estado de Wisconsin. Es un delito grave. Al ser condenado por este cargo, puede resultar una multa de $10,000 o prisión por hasta 6 años. También, por las provisiones del estatuto, su licencia puede ser suspendida o revocada por hasta 6 meses. The interpreter has completed a site translation of count 1, attempting to flee or elude an officer.
Thank you.
Gracias. Ilustrar ahí 1706, departamento 6.
Should be 1 or 7?
Perdón, es 1706 o 1106.
1706.
1706 apartment 6.
Okay. The address on the complaint appears to be correct as well.
Este es para usted.
All right, I'll make a finding of probable cause for the charge. Looks like there was an INS hold, but that was dropped or declined to be honored based upon the sheriff's policy. I do not see a public safety assessment. The state's position on bail.
Thank you. The state is asking that the court set cash bail in the amount of $500 for the conditions that the defendant not operate a motor vehicle and not consume or possess any alcohol during the pendency of this case. In support of this recommendation, I would highlight that the defendant is alleged to have fled from 2 different law enforcement agencies, traveling at quite high rates of speed. There were numerous bottles of alcohol allegedly located in his vehicle, which corresponds with his intoximeter results that came back with a 0.18. We are specifically asking the court set a condition of no operating motor vehicle rather than consider a less restrictive no operating motor vehicle without a valid license. Because to the state's knowledge, the defendant has no Wisconsin driver's license to begin with.
And Attorney Wyndham.
Yeah, well. Sorry. I called them. I have to figure out a way. I have to get out of it. Your question was if he. ¿Puede usted pagar los $500? Sí, can, but hard.
Yeah, we'd be seeking a signature bond. We'd have no objection to the non-monetary conditions at this time. Mr. Madriz is eligible for public defender services. He was working within the community for the past 2 years. And we believe that a signature bond would adequately ensure his appearance. I would note that there is a prior open case, 24 CM 1939. And there were no prior failures to appear in that matter. I believe that if we address the alcohol consumption, we can adequately ensure his appearance in court. Thank you.
Great. And is there a prior record other than this 24 CM case?
Hay alguna parte del caso del 2024.
Not that I'm aware of. In the state of Wisconsin, I haven't had an opportunity to review his history in other jurisdictions. It suggests that perhaps he doesn't have one by virtue of the fact that that case is open because he is in deferred prosecution through the DA's office.
All right, and the complaint mentions a driving record out of Texas. I didn't know if that was like non-criminal traffic offenses or criminal traffic offenses out of Texas for the defendant.
I'm not aware whether or not that is simply a criminal or simply a driving record or whether it extends to criminal offenses now.
All right. Well, there's some things in his favor. There doesn't appear to be much, if any, criminal record. There was a criminal misdemeanor case. He showed up to court for those particular proceedings and got a deferred prosecution. I'm not going to assume any of the traffic stuff out of Texas is criminal. I don't have any information to that. Does suggest that he's got ties outside the state of Wisconsin. The significant driving factor for me is the alleged behavior here. He's doing 90 miles an hour in highly trafficked areas, eluding one agency who then terminates their pursuit, and then another agency picks him up later on in the evening. I'm not sure how much time elapsed between that. And then allegedly flees from them and wasn't all that cooperative with law enforcement when they have contact with him. The alleged behavior to me is not indicative of somebody's going to show up without some cash bail on the line. I certainly have often set a lot more than $500 cash bail in eluding cases, taking into account the things that are in his favor. I think warrant something as low as that, but I'm not going to go below that. I'll set $500 cash bail. I do think, given the driving behavior, and apparently he doesn't have a valid driver's license, simply not operating a motor vehicle at all is the appropriate condition. And I'll order that he not possess or consume any alcohol at all. As to time limits for a preliminary hearing,
We'd ask for a timely prelim.
okay, we are adjourned.
Negative background. That's not those things.
They have a last.
Lema Tequila,
Do you have a last initial?
Lema Tequila,
Yes.
Tequila.
I think it's Danny song. Danny song? What's that one? Lema Tequila. Okay, so Bernalton is a middle name. His last name is Lema, and then Biglia. Probably misspelled on the form.
Okay, well, let's call the case. We'll call the state of Wisconsin versus Gustavo Bernalson, Lema Tequila, 25 CM 2982. We've got certified Spanish interpreter Fred Svensson, and
Fred Svensson.
if we've got the incorrect spelling of the last name, perhaps the interpreter can let us know how that's spelled.
Después I, it should be Tiglia. The I is ahead of the two L's, it should be after.
Okay, but is Lema Tequila all one word, or is that two separate words?
Two separate words, those different desafíos, them, yes, two glasses.
I see. So LEMA space and then the Tequila.
Yeah. And trying to say Gustavo Lem.
All right. Can we get the appearances?
Podemos hacer las comparecencias.
ADA Cecilia DeMarco for the state.
Gustavo Lema appears in person and in custody. And with Attorney Devontae Wyndham of the State Public Defender's Office. Mr. Lema is eligible for public defender.
¿Es esta la dirección suya o la de la? Aquí, están dentro. Sí, están tres. No vives aquí en 209 West de la Villa. No. So, y hay apartamento ahí, es casa. Es casa.
Best address is 1013 Vandenberg, VANDENBURG Street, Sun Prairie, 53590. We'd acknowledge receipt of the complaint. We'll waive its formal reading. I'm sorry, we'd ask that count one be read.
The interpreter can read that count one, Your Honor.
Thank you.
Resistencia a un oficial, el acusado nombrado para que el día sábado 13 de diciembre del pueblo de Guanaquí, condado de Dane, Wisconsin, a sabiendas resistió un oficial, que el oficial estaba con la capacidad legal, con la autoridad legal, por luchar físicamente con los oficiales. Esto está en contra de los estatutos del estado de Wisconsin, es un delito menor de clase A, y al ser condenado puede resultar una multa de $10,000 y cárcel hasta 9 meses. The interpreter is done doing a site translation of count one, Your Honor.
Thank you. And the interpreter's already been sworn for hearings this afternoon. I'll make a finding of probable cause and or not guilty plea. Looks like there had been an INS detainer lodged. The sheriff declined to honor that pursuant to their policy. We do not have a public safety assessment. What's the state's position on bail?
The state is willing to recommend a signature bond with standard conditions in this case.
No objection.
And is there a prior history that you're aware of?
I'm sorry, I don't have that information in my notes, so I just need 1 minute to check. As far as the state of Wisconsin, it looks like he's only ever had a conviction for a operating after revocation.
Okay. Well, Mr. Lema, the reason I'm pausing is the nature of the conduct here. Alleging that you weren't cooperative with law enforcement, resistive, obstructive. Given the lack of real prior record, I'm going to go along with the joint recommendation for a signature bond. But you probably want to make sure that you're complying with law enforcement going forward and making your court dates and not picking up any other cases. So it'll be a signature bond. I think you're going to get released today. I don't think anything else is holding it. We are adjourned.
Lo que pasa es que no quería decirles que yo me resistía a los buenos días. Sí, bueno, eso quería decirles.
Le van a asignar un abogado, mejor hablar con el abogado sobre eso.
Luckily, none of those complaints were very long. I was like,
That it for Fred?
That's it for me.
All right, thank you, Fred.
Jackson.
Arvenia Jackson, appearing to be the Zoom.
Right, we'll go on the record in the state of Wisconsin versus Arvenia Jackson. It's 25 CF 2868 appearances.
ADA Cecilia DeMarco for the state.
Lavinia Jackson appears via video and with Attorney Devontae Wyndham. Ms. Jackson, can you hear me okay?
Can you give us a thumbs up, Ms. Jackson, if you can hear us okay? All right, I see a thumbs up.
I also see a thumbs up. Will you acknowledge receipt of the complaint? We'll waive its formal reading. The address that we currently have is 630 East Washington Avenue. I understand that that's also across the street from where this incident's alleged to have occurred, so we might want to ask her what the best address for her to receive mail is. In addition, Ms. Jackson has not applied at this point in time for public defender services. I would ask that a copy of the public defender sheet be handed to her so that she may contact our office if she so chooses.
Okay, so Ms. Jackson, they're gonna give you the public defender info. If you can't hire an attorney after today, you can always apply.
Judge, I don't mean to interrupt you, but I don't use a public defender. I use attorneys. I don't pay for that right now. The reason why I say I don't want nobody to speak to me, they was not there at the scene of the situation, and I don't want to explain to a public defender what's going on. I don't think they qualify. I have a law degree and I have relatives, practice law, and I have had many attorneys represent me. And another thing, when we have a trial accused against you, the attorneys you represent, if they don't know, they don't answer detailed answers to say I'm guilty or not, they will have. I have been in the past had represented I paid them attorney, they lie. I don't want to deal with no public defender. Thank you, sir. I decline the public defender. Thank you.
Okay. We'll give the information anyways, in case you changed your mind. If you're not able to hire an attorney, you could always apply for a county appointed attorney if you're not eligible for a public defender. You do have the right to represent yourself, but that's not necessarily advisable.
Does she want me to represent her here at this hearing?
Well, it's a good question. Ms. Jackson, do you want Attorney Wyndham to assist you here today?
Repeat that, Judge. I didn't hear you.
Yes, would you like Attorney Wyndham to assist you here today?
He can, because I don't want to butt in towards what I'm saying, okay? I don't want to interrupt you, Judge. But I want to say the reason why I'm here. Also, I need housing and I need employment in the state of Wisconsin. I'm planning to make Wisconsin state my retirement home. This is a state of Wisconsin where my relatives have lived in over 100 years, okay? I'm 64.
Okay. So he'll assist you here today. You may not want to make statements about the facts of the case. You have the absolute right to remain silent. Anything you say is being recorded and can be used against you later on. I guess we'll come back to the address because I don't know what the state's asking for in bail, but remind me about that, Attorney Wyndham. I'll make a finding of probable cause for the charge. What's the state's position on bail?
Thank you. The state is asking that the court set $300 cash bail with standard conditions. I'm not seeing a specific request from the Beacon for the defendant to be banned from there. So I'm comfortable proceeding with standard conditions at this point. I am asking that you set cash bail given the lack of information the state has at its disposal regarding ties to the local community. It appears the defendant has a history of battery to a peace officer out of California, with the most recent conviction being in 2020. We're not certain what, if any, additional ties she has to the area, but this is an Act 3 offense. That conviction would be Act 3 eligible, and its equivalent here in Wisconsin as well. So given that information, I think $300 is the minimum amount appropriate.
Right. And Attorney Wyndham.
We'd be seeking a signature bond here. Obviously, Ms. Jackson, I don't have the eligibility requirements in regards to whether or not she's eligible for public defender services, but she was staying at a shelter in regards to on the night in question here on December 13th. In regards to ties to the community, she has mentioned having family members that reside within the community, as well as her family being residents of Wisconsin for the last 100 years. I think for all those reasons, a signature bond is appropriate here. I do believe that a signature bond could adequately have her appearance in court. There was a disturbance called here in regards to the facts of this case, and there was an allegation of a kicking circumstance. I don't believe that the Dane County Jail is the best place to house her, given the circumstances with law enforcement. And I do believe that giving Ms. Jackson an opportunity out within the community on the signature bond would be appropriate at this time. Thank you.
All right. Any response from the state?
I don't have anything to add. Thank you.
Well, the nature of the charge is an Act 3 eligible offense. I don't have much of a concrete history in regards to other Act 3 crimes and crimes of violence. There was a reference in the complaint, an admission by Ms. Jackson that she may have had a felony in another state or out of Milwaukee for an assault to a security guard. I didn't find anything. I gather the state didn't find anything in the state of Wisconsin, or that would have been mentioned, because if she had a prior Act 3 eligible conviction, that would have been relevant. This is one where it's kind of a sad situation. It almost reads like she was looking to get a felony so she could stay in jail. At least that's her professed reasons to law enforcement. And when they told her the obstructing wasn't a felony, then we ended up with the physical altercation with law enforcement. I guess I'm not satisfied there's a need for cash bail under an Act 3 analysis. If it was, I generally wouldn't set something as low as $300. I don't think it's usually something that's going to protect the public. There is the concerns about significant ties or lack thereof. She's providing a local address to get mail. I'm willing to give her an opportunity and expect that she'll make her court dates without the need for cash bail. So order a signature bond with the statutory conditions. What about time limits for the preliminary hearing?
We'd waive time limits at this time. Or actually, given her lack of wanting SPD, I would ask for a timely prelim. I just don't want to waive anything that she may want timely.
Okay, or we could have her unmute and I can ask what her position is. So Ms. Jackson, you have the right to a preliminary hearing within the next 20 days. Do you want that scheduled within the 20 days?
I want to interrupt the judge. I do not want a bond. I appreciate the lady here that said what she said. What you said is true. They gave me a little civil charge. I told them no, I need something to stick overnight because whatever happened over there, Salvation Army at the address of 630 East Western, there's meth dealing in that thing, and that's what causes problem. I don't like to be around.
Okay, so Ms. Jackson, you're talking a little fast. It's hard for me to catch everything. Do you want your preliminary hearing scheduled within the next 20 days, or do you want more time before that's scheduled?
Off right now because I have to get somebody to represent me. Either I have to use like this little lady here with it.
Okay, so we can set it for a status to give you more time so you can hire an attorney. That's fine.
One other thing, I got another case in the DeKalb County.
Okay. Yeah, I wasn't aware of that. So I ordered a signature bond. So if you decide to,
no bond, sir. I'm staying in jail.
yeah, if you don't sign it, then they're probably not going to release you. But if you sign it, then you should get released. I don't think anything else is holding you. We'll be adjourned. Take care.
Next is Danielle Ackland.
Great. Go on the record in the state of Wisconsin versus Danielle Ackland. It's 25 CM 2983 appearances.
ADA Cecilia DeMarco for the state.
Danielle Ackland appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. We acknowledge receipt of the complaint. We'll waive its formal reading. The address on the complaint appears to be correct. Mr. Ackland is eligible for public defender services. Stand mute to the charges.
Right. So I think there's a contempt of court in place. That's a civil matter. You're going to have to address that with the family court. I can't do anything with that here today. I'll make a finding of probable cause for the charges. One or not guilty pleas to those. There is a public safety assessment report. It recommends a signature bond. What's the state's position on bail?
The state echoes that recommendation. We would ask that as the sole condition, the court order the defendant direct no acts or threats of violence towards Nicole, common spelling, last initial P.
Right. Any objections?
No.
Okay. Order a signature bond. Condition will be that you direct no acts or threats of violence towards Nicole P. And again, you're either going to have to pay the purge amount or file something with the family court to address that to contempt of court. Otherwise, you'll sit out the sanction. Okay. We are adjourned. Yep.
Yellow lights, please.
We'll go on the record in the state of Wisconsin versus Charles Moore. It's 25 CF 2866 appearances.
ADA Cecilia DeMarco for the state.
Charles Moore appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. This time, Mr. Moore is not eligible for public defender services. I'm handing him a copy of the public defender sheet, so that if he wishes to apply. We'd acknowledge receipt of the complaint. We'll stand mute to the misdemeanor charges, and the address on the complaint appears to be correct.
Okay, so Mr. Moore, you have the right to an attorney. If you can't hire one after today, you could apply for a county appointed attorney. That's the middle option. Public Defender's Office can point you in the right direction. You've been handed their information, or you can always reapply with the public defender. We'll make findings of probable cause and are not guilty pleas to the misdemeanor charges. I don't believe we have a PSA report, state's position on bail.
Thank you. The state is asking that the court set cash bail in the amount of $2,500. As conditions, we'll ask the defendant be ordered not to operate any motor vehicle, not to possess or consume any alcohol, not to possess or consume any controlled substances or drug paraphernalia without a valid prescription, and that the court consider a referral to pretrial services to monitor alcohol and substance usage should the court accept the state's recommendation. In support, I'll note that the defendant is now facing a 6th operating while intoxicated charge, which comes with presumptive prison time. It's alleged that he admitted to both smoking marijuana and drinking beers. He's under a lifetime driver's license revocation, as well as subject to bail conditions in 3 different cases. 2 of those are outside of Dane County, in Walworth County, 1 here in Dane. Those all have conditions of either no operating a motor vehicle or no driving without a valid driver's license and IID. Yet here it's evidenced by the allegations that the state has evidence the defendant simply continues to drive. So anything less than a blanket no drive condition will simply not be a sufficient deterrent. It's also clear from the existence of those cases I just mentioned that the defendant has either an unwillingness or inability to follow lawful court orders to not operate a motor vehicle while these cases are pending and while he's under the influence. So the state does believe some cash is necessary. As far as failures to appear go, the most recent failure to appear I see was a missed court date from January of 2022. Other than that, the list goes back up to dates that are a bit older that I'm not sure the court's interested in.
And when you say that, is that back to the 2012 or later OWI convictions?
No, apparently he missed court on the same case in October of 2021, but since it's been 4 years now, I didn't bother mentioning it at first.
Okay. And Attorney Wyndham?
Yeah, we'd be seeking a more modest amount of cash bail here. I would note that Mr. Moore has resided in Wisconsin all his life. In addition to that, he is currently working within the community. He is working at Franklin Electronics. In addition to the circumstances surrounding the court appearances, as well as the current eligibility for public defender services, I'm not sure what's going on with his eligibility, because he was found eligible for public defender services in a prior case, and for whatever reason, the calculus here for this case, he's not found eligible. So I think that needs to be rechecked, and I hope that he reapplies. So I do believe that there is some indigency status going on in regards to the circumstances, both due to that as well as the address here. I think a more modest amount of cash would be appropriate. I think in the amount of $500 to $1,000 would adequately ensure his appearance in court, as well as ensure that those bail conditions are being followed. We'd have no objection to the bail, to the non-monetary conditions here. I don't think pretrial services is necessary. I'm not sure if the state had requested that prior. But I do believe that the non-operation, as well as the no alcohol or other drugs, would be appropriate at this point in time. So for those reasons, I do believe that amount in the amount of $500 to $1,000 would adequately ensure the appearance, as well as be a manageable amount for a person of Mr. Moore's financial status. Thank you.
All right. Well, I think there's a need for cash. He's looking at mandatory prison if convicted here. There's been a couple of failures to appear in the last, 4 or 5 years. And he was out on bail in an OAR case where he was ordered not to operate a motor vehicle and then allegedly was operating a motor vehicle while intoxicated. I'm willing to set it at a lesser amount. I'll set it at $1,500 cash bail. I do think pretrial services is necessary, though. He's already been given simple orders to not operate a motor vehicle. He's ignored that. So I think we need to make sure that he's also not drinking and using controlled substances to protect the public. So if you do post bail, Mr. Moore, you got to report to pretrial services no later than 10 a.m. on the business day following your release. They're on the 5th floor of the Dane County Courthouse. The deputies are going to give you the map to the pretrial services office, so you know where that is. I'll order that they test you for alcohol use and controlled substances. I'll order that you not possess or consume any alcohol, use or possess controlled substances or drug paraphernalia without a valid prescription, and again, order that you not operate a motor vehicle. What about time limits?
We'd ask for a timely prelim.
Okay, we are adjourned.
Next is Benjamin Howell, appearing via Zoom.
Right, we'll call the state of Wisconsin versus Benjamin Howe. It's 25 CM 2984 appearances.
ADA Cecilia DeMarco for the state.
Benjamin Howell appears via Zoom and with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Howell, can you hear me okay?
Go ahead and respond.
Mr. Howe, if you can hear us okay, can you indicate that or maybe give us a thumbs up in the window? All right, you see a thumbs up.
I also see a thumbs up. Your Honor, we'd acknowledge receipt of the complaint. The address on the complaint appears to be correct. Mr. Howell is eligible for public defender services. We'd stand mute to the charges.
All right, I'll make findings of probable cause, enter not guilty pleas. I don't believe there's a PSA report, state's position on bail.
Thank you. The state is asking that the court set $250 cash bail with conditions that the defendant have no contact with Kevin, common spelling, last initial B as in boy, and be banned from the 2000 block of Zier, Zeier Road in Madison. I think this would normally be a signature bond case, but for the fact that the defendant is out on bond in 2 other Dane County cases and did post a minimal amount of cash bond in the form of $150 in 25 CM 2910 back on November 21st of this year. I think the next logical step in the analysis, given the conditions I've just laid out for the court here, is for a small amount of cash bail to be set in this matter as well. So I would ask that you follow the state's recommendation.
Right, and Attorney Wyndham.
Yeah, we'll be seeking a signature bond in regards to this matter. Mr. Howell is eligible for public defender services. He's resided in Wisconsin for the past 8 years. He has parents and his extended family within the community. In addition, he is currently working at Jimmy John's here within the community as well. For all those reasons, I do believe that a signature bond would adequately ensure his appearance in court. This is not an Act 3 eligible case. And so for those reasons, I do believe that a signature bond would be appropriate.
And I should note in 25 CM 2910, it looks like he posted $150 cash bail, got an order in date, and maybe was in custody on that other DC case, and he was given signature bonds on both cases. So I don't think he's out on cash bail right now unless somebody's seen something different. I should note I see the PSA report in that case indicated no prior felony convictions and no failures to appear, and had recommended a signature bond back on December 8th. Anything else, Attorney Wyndham?
No, Your Honor.
Anything else from the state?
No, I don't have anything to add.
I think it's a close call, but I'm willing to try a signature bond given the nature of the charge and the lack of failures to appear. I'll order a signature bond. I'll order a no contact direct or indirect with Kevin B and a ban from the 2000 block of Zier Road. If we're back yet again, Mr. Howe, then we may have to be ordering cash bail at that point. So please don't put yourself in that position. We are adjourned.
Next is William Hamilton. Hamilton here.
We'll call the state of Wisconsin versus William Hamilton. It's 24 CM 1730 appearances.
EDA Cecilia DeMarco for the state.
My office. For this amendment, but ultimately the decision about.
Can I change my mind in the middle of it, like if I see like abundance of questions that I mean, I might feel uncomfortable with, can I change areas? Like self-represent, just do the whole thing kind of thing.
You would not be required to self-represent yourself throughout the entire thing, but if you would like me to help you out in regards to, you know, the case here today, I can help you out to ultimately that decision.
I think I'll be fine.
Okay. Your Honor, Mr. Hamilton has elected to represent himself at this hearing.
Okay, and Mr. Hamilton, you understand that you have the absolute right to an attorney? All right, you understand that you're potentially at a disadvantage trying to represent yourself against the state's trained lawyers?
Yes, sir.
And you read and write the English language? Read and write the English language?
Oh, yes.
And how far did you go in school?
A bachelor's degree in public medicine.
Okay, well, if you change your mind during this hearing, Attorney Wyndham is an experienced attorney and can assist you. And you're certainly free to hire an attorney after today if you're able. If you can't, you could apply with the Public Defender's Office. I don't know, he didn't go through the evaluation, I assume, given his position.
That's right.
All right.
Copy of the sheet was needed.
All right, thank you. So they've given you the public defender info, so if later on as the case proceeds, you decide that you need representation, you can always apply with them, and if you're eligible, they'll get you a lawyer at little or no expense. You've got a copy of the criminal complaint in front of you?
I do.
Alleges criminal damage to property, that's a Class A misdemeanor, punishable up to a fine of $10,000 in imprisonment for not more than 9 months or both. We have an address in the upper left-hand corner for you. Is that the best place to get mail?
Oh, yes.
All right, I'll make a finding of probable cause for the charge. Don't believe there's a public safety assessment report. What's the state's position on bail?
The state would normally be asking for a signature bond, but given the length of time that the defendant was in warrant status, we will ask that you set $350 cash bond. We would ask as a condition that the defendant not operate any motor vehicle without a valid driver's license. To make a more thorough record here, the initial appearance was first scheduled to take place on August 26th. It was adjourned to ensure that the defendant was personally served with his notice. I do have an affidavit of service here from the Dane County Sheriff's Office indicating that the defendant's mother was served at the very same address that we had on file for him just days later on August 29th of 2024, which indicates he had notice of the initial appearance that he then failed to appear for 1 month later on September 26th of 2024. He knew about his court date. Over a year passed, now we're here. I think this is a modest cash bail situation, so I'll ask that you follow the state's recommendation for the reasons I've just mentioned.
All right, and Mr. Hamilton, your position on bail?
My father passed away around this time. I guess, like I can pay bail, but I have the money in like a cash income. I'm not sure what the math is. I would still be able to do my card. From Schmitz, which was told Sunday I was arrested.
Okay, and when did your father pass away?
This would have been like basically a month after this incident.
Okay, and how come you didn't take care of the warrant since then? It's been out for over a year.
I've been homeless for a year. I was trying to get a place before I kind of took care of it. I thought I would probably be taking care of that a lot.
Okay, and I'm sorry, you said you think you can post cash bail?
Yes, it's I think I have like 700 now with daily pay, and so my little Schmitz, and I'm also not fired, so I definitely can I was worried if I would be fined, that I might have load of what she was assessing for my car. But I do have all the money. I would have that on Thursday, or I could. My mom has my cell phone. I can also just process the pay right away. And to pay that.
Okay, so I just want to be clear, are you agreeing to the $350 bail, or are you asking for something different?
I think I would be able to go for it with that as well.
Okay.
With that.
All right, well, I'm sorry to hear about your father passing, but this is something that really needed to be taken care of a lot sooner than now. Given the length of time that you've been out on the warrant and would have had knowledge of that, I think the cash is appropriate. I'll adopt the stipulation for $350 cash bail, order that you not operate a motor vehicle unless you have a valid driver's license. And we'll be adjourned. You can go with the bailiffs.
Bradley Osborne is next. Osborne. Stand at the podium.
Well, the County of Dane versus Bradley Osborne, it's 25 FO 2479 appearances.
ADA Cecilia DeMarco for the state.
Mr. Osborne appears in custody in person without counsel. Mr. Osborne, are you using the Aberg Job Center as a mailing address?
Yeah, that's right.
Okay, so good news, you're not getting charged with a crime, even though they arrested you for criminal charges. You're getting charged with forfeiture. That's more like a speeding ticket. It's possession of drug paraphernalia as a county ordinance. They are going to have an offer. If you want to accept that offer, you can be done with the case. If you don't want to accept it, you're still going to get released no matter what, because I don't think there's anything else holding you, okay?
Okay.
All right, is there an offer?
Yeah, the state is willing to resolve the matter for the payment of court costs only, no additional fines.
Okay, so it's going to be $114.50. That would either need to be paid within the next 60 days or work out a payment plan with the clerk's office if you need more time. It's not something you have to pay up front like bail to get released. You're getting released no matter what. Did you want to accept that offer? Do you want to contest the charges?
That seems acceptable to me.
All right,
I would
I'll
like to
accept that as a no contest plea to the charge, or do you pay the court costs? They're going to give you some info about paying the forfeiture, and they'll process and release you yet today. Okay, we are adjourned.
Right this way.
Next is SAKI Burrell. Burrell.
We'll go on the record in the state of Wisconsin versus SAKI Burrell. That's 25 CF 2864 appearances.
ADA Cecilia DeMarco for the state.
Mr. Burrell appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. We're unaware at this time if Mr. Burrell is eligible for public defender services. I'm handing him a copy of the public defender sheet if he wishes to apply. I believe the best address for Mr. Burrell to receive mail at is 1819 Aberg Avenue, care of the Job Center. We'd acknowledge receipt of the complaint. We'll waive its formal reading.
All right, and Mr. Burrell, they've given you the public defender info. If you can't hire an attorney after today, you could apply for a county appointed attorney. That's the middle option, or reapply with the public defender's office. The public defender can kind of point you in the right direction if you need to apply for a county attorney. We'll make findings of probable cause. And I don't believe we have a public safety assessment report. What's the state's position on bail?
Thank you. The state is asking that the court set cash bail at $2,000 with conditions that the defendant not use or possess any controlled substances or drug paraphernalia without a valid prescription. In support, I would note that the defendant is alleged to have been arrested with tens of thousands of dollars worth of drugs in also allegedly stolen vehicle that he had just been operating. While I'm not aware of any criminal convictions, he does have a pending case where he is on bond for fleeing in another stolen vehicle. All of these indicate quite a heightened bail risk from the state's perspective. It's clear that he had access to some amounts of currency, given that he was arrested with over $2,400 on him, in addition to these high dollar amounts worth of illicit substances. So for all of those reasons, the state is asking that you adopt its recommendation in full.
And Attorney Wyndham?
Now, I would be seeking a more modest amount of cash. I would note that Mr. Burrell has been found eligible for public defender services in the past. He does have Attorney Lencioni from my office on that other case. In addition to that, Mr. Burrell is a lifelong resident of Wisconsin. He's 19 years old. He is currently working. He's been working at Arby's here within the community for the past 8 months. He has parents and siblings and friends within the community. I think for all those reasons, a more modest amount of cash would be appropriate. I think something in the amount of $500 to $1,000 would be appropriate. Thank you.
All right, and any response from the state?
No, I think my prior argument outlines all of the reasons sufficiently, so I'll let the court decide now.
So if I'm reading the complaint correctly, I'm not sure count 2's charged out as bad as it could be for Mr. Burrell, as they allege 10 to 50 grams of fentanyl, and it alleges that there's like well over 100 grams of fentanyl. I think under those particular weights, he's looking at mandatory minimum prison sentences in federal court. There's also fairly significant weights for the methamphetamine and the cocaine, but not such that he would be looking at necessarily mandatory minimums in federal court on those particular charges. But that certainly, I think, provides an incentive to not appear in court, because there is always the potential that this is merely just a placeholder and the feds are going to potentially indict you, given the weights of the drugs here. And that adds incentive not to appear in court. It's concerning. He was already out on bail for a flee and elude. And the state's requested cash bail, quite frankly, is less than the amount that he had on his person. I probably could be persuaded to find a more significant cash bail as appropriate, given the sheer weights of the fentanyl. I'm not going to go above what the state's recommended, but I'm certainly not going to go below it. I'll set $2,000 cash bail, order that you not use or possess any controlled substances or drug paraphernalia without a valid prescription. We can get him a prelim in the next 10 days if you'd like, though.
Yes, please. Thank you.
Okay, we are adjourned.
Next is Preston Valencia-Rios. Rios.
On the record in the state of Wisconsin versus Preston Valencia-Rios, 25 CM 2980 appearances.
ADA is Cecilia DeMarco for the state.
My name is Attorney Bobby, and I'm out of the defender's office with 5%. I'm here to help you out for the day. You want me to help you out here today, or do you want me to represent you? This one?
Okay. All right. Mr. Valencia-Rios has declined SPD. I'm gonna still probably hand him a copy of the state public defender sheet, and he's electing to represent himself at this moment.
Okay,
Sure.
sir, a couple things. They're going to give you the public defender information. If you change your mind after today, you can reapply with them and see if you're eligible. You're certainly free to hire an attorney on your own after today. You do understand that you have the absolute right to an attorney?
Correct.
All right, and you understand that you may be at a disadvantage representing yourself?
Correct.
All right, and you read and write the English language? All right, and how far did you go in school?
Went to high school, graduated high school.
Okay, you've got a copy of the criminal complaint there?
All good.
Do we have a good mailing address for you on that? All right, and do you need me to read the charges to you? You're able to do that on your own?
Yeah.
All right. I'll make findings of probable cause and are not guilty pleas to the charges, state's position on bail.
Thank you. The state is willing to recommend a signature bond. We're asking that as conditions, the defendant be banned from the 5900 block of Dragonfly Way in McFarland, and that he have no contact with Rihanna, Rianna, last initial R, and Kristen, Kristin, last initial V.
Right, and Mr. Valenza-Rios, any objection to those bond conditions?
Not to speak, or was it against?
Do you have an objection to any of those bond conditions?
Abject.
Okay, any argument you want to make? And before you do that,
No.
you do have the right to remain silent. Anything you say here could be used against you, so you probably don't want to talk about the facts of the case. But if you want to talk about reasons why you need to have contact with these particular individuals, or why you shouldn't enter the address ban, I'm happy to hear that. So any argument you want to make?
I probably just stay silent.
Okay, let me take a look at the complaint here. And if I order the no contacts in the ban, is there someplace else that you could reside or get mail?
No.
All right. Well, given what's alleged and the victim's express wishes, or at least the most recent wishes that I'm aware of, they didn't want contact, so I'm going to honor their wishes. So I will order a signature bond. So you're going to get released from custody. I'm going to order a no contact, direct or indirect, with Rihanna R and Kristen B, and a ban from the 5900 block of Dragonfly Way. If you need to get any items from the residents, you need to contact law enforcement and arrange for preserve the peace and go with law enforcement to get those items. Don't have contact with the victims or go back there if you're not in the presence of law enforcement. Even if the victims reach out to you, you can't have contact with them until the court has modified the bond conditions. You're certainly free to file a motion on your own or have an attorney do that, and have that addressed by the court. But until it's modified or changed, you can't have contact with these two individuals or be at the 5900 block of Dragonfly. Understood?
Also, I would like to say, they do know that I'm coming, so I'm just trying to say, if they do object to, I would like to see if they would want to speak to me just by themselves. Because I really have no sort of say.
I've entered the order, and that's what that's the most recent wishes that I have from them. So. Yeah, so you can't have contact with them. You understand that. You'd have to have a lawyer file a motion or file a motion on your behalf. They're certainly free to contact the DA's office or contact the court if they change their mind, but they asked that the 72-hour no contacts be enforced against you. And that's the best information I have. So I'm ordering those no contacts. So you can't have any contact with them. No, I'm saying that's the information I got from them.
Yeah,
So I'm ordering it as a bond condition here today, which means it's a bond condition until it's modified by the court. Can't be modified by the parties. It isn't a 72-hour ban. It's a total ban until the case is ended or it's modified by the court. Understood?
So I understand that part. So is the case not over with? It's not done?
No, it's a criminal case. It's not done. You'll get another court date. Criminal cases can often take 12 months or more to be resolved. So as long as the case is pending, those are the bond conditions. You have to have no contact with those individuals, be banned from the Dragonfly address, unless a motion is filed and the judge decides to change the bond conditions. That's the only way it can be modified. Understood?
I get it.
Okay, good. Then we are adjourned. Take care.
Next is Elizabeth Fitzgerald.
That's not one SPD, this is chaos.
I'm sorry, did you say Fitzgerald?
Yes.
All right, we'll call the record in the state of Wisconsin versus Elizabeth Fitzgerald. It's 25 CM 2970 appearances.
ADA Cecilia DeMarco for the state.
Elizabeth Fitzgerald appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. We are unaware at this time if Ms. Fitzgerald is eligible for public defender services. I have handed her a copy of the public defender sheet. Ms. Fitzgerald, that's the address. Correct. The address on the complaint appears to be correct. We'll waive its formal reading and we'll stand mute to count one.
Okay, and Ms. Fitzgerald, we're going to give you the public defender info. I think you've been provided that. So if you can't hire an attorney after today, give the public defender a call and you may be eligible for an attorney at little or no expense. If you're caught in the middle, you could apply for what's called a county attorney. I'll make a finding of probable cause. We'll get a not guilty plea entered to the charge. And I don't see a PSA report, state's position on bail.
Thank you. The state thinks a signature bond is appropriate here. We would ask that as a sole condition, the defendant be banned from Eno Vino Restaurant, ENO space VINO. I believe that's located on North Webster Street in downtown Madison.
Any objections?
Your Honor, I just want to be a little clearer. Eno Vino, I believe, is inside of a hotel. Are we asking that she be banned from the entirety of the hotel or just from the restaurant portion of that hotel?
Attorney DeMarco?
Yes, it is part of the hotel. So banning her just from the restaurant portion, I guess, is fine. I don't know what makes the most sense. I think it's up to the court at this point.
Okay, well, your position on the address ban?
We'd have no objection. If the court wants to make it clearer for the purposes, I just don't want Ms. Fitzgerald to be caught in a situation where she's considered violating the conditions by being downstairs when the restaurant, I believe, is on the rooftop of that hotel.
All right, is there any reason she needs to be in the hotel?
Not that I'm aware of.
Um,
She will need a protection of the police to get her vehicle from the property, though.
all right, I'm just gonna enter an order that says that she be banned from, I believe it would be the AC Hotel, which includes Eno Vino and on North Webster. You can contact law enforcement to go with you to get your vehicle, or maybe some third party can pick it up. I don't know. But you can't go back there while this case is pending. As a condition of your signature bond, you'll be adjourned.
That's it, all that it is.
What's up, Richard?
Okay. Great.
Okay, we'll call the County of Dane. This is Paulette Riggins. It's 25 FO 2477 appearances.
ADA Cecilia DeMarco for the state. The defendant appears in person in custody without counsel.
All right, and Ms. Riggins, the good news is, even though you got arrested for criminal charges, I don't believe you're getting charged with any criminal charges. They've charged you with something that's more like a speeding ticket, a county disorderly conduct. So that's non-criminal. They're gonna have an offer, and if you want to accept the offer, you could be done with the case. If you don't want to accept the offer, you're still gonna get released no matter what you do, because I don't think there's anything else holding you, okay? Do we have a good address on the complaint, though, for you to get mail from the
Is
court?
that here?
Yeah, under your name on Morgan
Yes,
Road.
1162 Moreland Road, 201 Madison, Wisconsin. Yes, that's correct here.
Okay, very good. What's the county's offer?
We're willing to offer costs only, no additional fines.
Okay, so if you wanted to plead to the charge, it would be court costs of $114.50 to either pay within the next 60 days or work out a payment plan if you needed more time. Did you want to accept their offer? Or do you want to contest the charges?
To accept the offer and
Okay,
just
I'll
pay.
accept that as your no contest plea to the charge, or you pay the court costs of $114.50. The deputies are going to give you some info about sending in the payments, and they'll process and release you yet today, okay?
Okay, that sounds good. Thank you, for that. I appreciate that.
Yep.
And
Any
was there,
questions?
how would I go by paying, this?
They're gonna give you some
That- okay.
info about that,
Okay.
so you don't have to pay it up front like bail or anything.
Okay.
Just pay it in the next 60 days or contact the clerk's office if you need more time beyond the 60 days to pay, okay?
Okay, 60, okay, and I have 60 days. Thank you.
Yep, you're welcome.
Next is your colleague, Bolini Gonzalez. Oh.
We'll go on the record in the state of Wisconsin versus Joseph Gonzalez Yerbolini. That's 25 CM 2981 appearances.
ADA Cecilia DeMarco for the state.
Joseph Gonzalez Garbolini appears in person and with Attorney Devontae Wyndham for the State Public Defender's Office. Mr. Gonzalez is eligible for public defender services. We acknowledge receipt of the complaints. We'll waive its formal reading, stand mute to count one. The address on the complaint appears, should it be apartment number 8 or apartment number 8? Okay. The address on the complaint appears to be correct. And Mr. Gonzalez is eligible for public defender services if I haven't said that previously.
Okay, I'll make a finding of probable cause, get a not guilty plea entered. There's a public safety assessment and recommends a signature bond. What is the state's position on bail?
Thank you. The state is willing to recommend a signature bond in this case with the sole condition that the defendant have no contact with the victim whose initials are D as in dog, Q as in Quincy, N as in no.
Any objections?
No.
Great, we'll order a signature bond. Condition will be a no contact director and director of the victim with the initials DQN, and we are adjourned.
Okay, this was. Next is Xavier Vaughn. 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 Christopher Springer. Springer. The Doss. Doss. They have Sam. Yeah, that's a big deal, but.
Go by Mr. Doss?
Yes, please.
Okay.
All right, we'll go on the record in the state of Wisconsin versus Christopher Springer. It's 25 CF 2404 and 25 CM 2977 appearances.
ADA Cecilia DeMarco for the state.
Christopher Doss appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. At this point in time, Mr. Doss has been found not eligible for public defender services. I'm handing him a copy of the public defender sheet if he wishes to apply. One of the addresses is correct, the 5666 King James Court, Apartment 3, Fitchburg, Wisconsin. Should be the address for both cases.
Okay, and so Mr. Springer, sounds like you make too much money to be eligible for a public defender.
I want to retire as bus now.
That's fine. Attorney Wyndham is going to assist you today. You have the right to an attorney after today. If you can't hire one, you could apply for a county attorney. That's the middle option. The public defender can point you in the right direction to assist you with that. That's their information.
Okay.
Or you can always reapply.
Okay.
We'll make finding of probable cause for the charges and our not guilty plea to the misdemeanor. Looks like there's a hold for a contempt of court out of Portage County. Obviously, that's something I can't address here today. You'll have to address that with them. And then we'll address bail. What's the state's position on bail?
The state is willing to recommend signature bonds in each of these cases. In 25 CF 2404 will ask that the defendant be subject to conditions that he not possess any financial instruments that are not issued in his own name, that he have no contact with the Hug for a Heart organization. In 25 CM 2977, we're recommending standard conditions with the signature bond.
Right, any objections?
No.
Right, I'll order a signature bond in both cases. In the misdemeanor case, it'll be the statutory conditions. I'll order that you have no contact with the Hug for a Heart organization or any of their employees, and that you also not use or possess any financial instruments or documents that are not lawfully in your own name. And you're gonna have the right to a preliminary hearing on the felony in the next 20 days. Your position on that?
I understand. We're, okay, waiving time limits on that case.
Okay, we are adjourned.
Next is Akeem Johnson.
Just a second. He did, yeah.
Akeem Johnson. Johnson.
We'll go on the record in the state of Wisconsin versus Akeem Johnson. It's 25 CF 2869 appearances.
88 Celia DeMarco for the state.
Akeem Johnson appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Johnson is eligible for public defender services. We acknowledge receipt of the complaint. We'll waive its formal reading, stand mute to any misdemeanor charges. And the best address for Mr. Johnson to receive mail is 1819 Aberg Avenue.
Okay, looks like there's a DOC hold that's still in place. I'll make a finding of probable cause and are not guilty pleas to the misdemeanors. There's no PSA report because he's been in on the hold. State's position on bail.
The state is recommending cash bail in the amount of $750 in this case. As conditions, will ask that the defendant have no contact with Ariel, ARIEL, last initial B as in boy, and that he be ordered not to use or possess any dangerous weapons as defined by the Wisconsin statutes. In support of this recommendation, I will highlight the fact that this is an Act 3 eligible case by virtue of count 1. It's also my understanding that the defendant, while on a DOC hold, making bail somewhat academic, he also has not performed well on supervision. He started supervision on August 5th of this year and has apparently been absconding almost immediately since then. The start of being in formal absconding status with DOC is August 29th, so he didn't even make it a month. I think this supports the state's recommendation of $750 cash bail, so I'll ask that you adopt our recommendation in full.
And Attorney Wyndham.
We'll be seeking a signature bond. Mr. Johnson is eligible for public defender services. He's currently attending school at MATC part-time. He's also has a 17-year-old child that lives with him. He also has family, friends, and extended family that reside within the community. He's been residing here for the last 15 years. I think due to his ties within the community, as well as the fact that he's currently going to school within the community, as well as his public defender eligibility, I do believe that a signature bond or a more modest amount of cash would be appropriate. I understand that this is more academic given the nature of the PO hold, but I do believe that a signature bond would be appropriate at this time. Thank you.
All right, I think cash bail is necessary to assure appearance in court, given the absconder status and the lying about who he was at the time he has contact with law enforcement. But I think there's also a credible Act 3 argument here. He's out on an Act 3 offense, burglary on supervision, and then allegedly commits a substantial battery with a dangerous weapon. In fact, all counts 1 and 2 are Act 3 eligible offenses. I think I probably could have been persuaded to order something higher than 750. I'm not going to go above it, but I don't see any basis to go below it. I'll set $750 cash bail. Order no contact, direct or indirect with Aerial B, and that you not use or possess dangerous weapons as that's defined by the state statutes. You do have the right to a preliminary hearing in 10 days.
We would ask for a timely prelim.
Okay, we are adjourned. All right, this way.
Stephen Hogginson. Hogginson.
Right, we'll go on the record in the state of Wisconsin versus Stephen Hogginson. It's 25 CM 2971 appearances.
ADA Cecilia DeMarco for the state.
Stephen Hogginson appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Hogginson is eligible for public defender services. We acknowledge receipt of the complaint. We'll waive its formal reading. We'll stand mute to the charges. The best address for Mr. Hogginson to receive mail is 1819 Middleton Street in Middleton, Wisconsin, 53562.
Great, thank you. I'll make findings of probable cause, enter not guilty, please. The public safety assessment recommends a signature bond, state's position on bail.
The state is recommending modest cash bail in the amount of $350. We're asking that the defendant be banned from Tanner's, TANNERS bar in Middleton, and that the court consider general ban from the 2200 block of Deming Way in Middleton that would encompass that establishment. We will also ask that the defendant be ordered not to use or possess any alcohol during the pendency of this matter, and that he be monitored via pretrial services should the court adopt the state's recommendation. In support, I will note that this is now the defendant's third open case in a span of approximately 1 month, all of which it's my understanding involve allegations that center on use of alcohol. It's alleged that the defendant PBT'd at a 0.296 while causing a disturbance here, which makes it clear that some higher level of intervention than what has been said in previous bonds is necessary. It's clear he needs some type of monitoring as well, and the fact that he is continuing to commit new crimes allegedly while out on bond does not bode well for future compliance with court orders. I do see that there were some bench warrants issued in recent history. It looks like bench warrants were issued in 2 different Dane County cases on June 9th of 2023, and those were not served until months later in November 8th, or on November 8th, excuse me, of that same year, 2023.
All right, I don't believe the PSA report has any failures to appear. Do you know, within, oh, take that back. They do have a failure to appear older than 2 years, none within the last 2 years. And Attorney Wyndham, your position on bail?
Yeah, I think that's consistent. The PSA is recommending a signature bond in regards to the circumstances. It is saying to report and comply with pretrial services. I recognize why in relation to the rapid succession of the cases, and however, I do believe that given the nature of these charges, the disorderly conduct and the misdemeanor bail jumping, It's very unlikely that Mr. Hagerson would be subject to significant incarceration. I think the incentive for flight is very low. He is eligible for public defender services. He does currently rent within the community. He's resided here in Dane County the entirety of his life. And so for all those reasons, I do believe that given his ties to the community as well as his eligibility, his appearance in court can be adequately insured through a signature bond. As far as protecting the public and following bail conditions, I do believe that the non-monetary conditions are appropriate, though I think the need for pretrial services is not quite there yet, given the nature of this charge being a disorderly conduct and bail jumping. Thank you.
All right. Well, I'm kind of in between the two of you. I think given we're now on the third case, there's a need for some cash bail. There was a failure to appear just outside the 2-year mark. But I don't know, given the nature of the charges, that I want to use pretrial services. It's a limited resource. I'll set $250 cash bail, order a ban from Tanner's in Middleton, as well as a ban from the 2200 block of Deming Way, and that you not possess or consume any alcohol. But he doesn't need to report to pretrial services. We'll be adjourned.
Yep. Next is Ryan Johnson. Johnson. Good. Please.
All right, we'll go on the record in the state of Wisconsin versus Brian Johnson as 25 CF 2863 appearances.
ADA Cecilia DeMarco for the state.
Brian Johnson appears in person and in custody with Attorney Devontae Wyndham for the State Public Defender's Office. Mr. Johnson is not eligible for public defender services. I have handed him a copy of the public defender sheet. At this time, we'll acknowledge receipt of the complaint. We'll waive its formal reading. We'll stand mute to count 2. And the address on the complaint is mostly correct. There just needs to be an apartment number 1 added to the address.
Okay, and I'm sorry, did you give him the public defender info?
I did.
So, sir, you have the right to an attorney. If you can't hire one after today, you could apply for a county attorney. That's the middle option. Or you could reapply with the public defender's office, and they can also point you in the right direction if you need to apply for a county attorney. I'll make findings of probable cause and are not guilty pleas to the misdemeanors. I don't see a PSA report. What's the state's position on bail?
The state is willing to recommend a signature bond here. As conditions, we will ask the defendant have no contact with Michelle, common spelling, last initial A as in apple, or any of their children in common whose initials are BMJ and BRJ. Then he be ordered not to use or possess any alcohol during the time that the case is pending.
Okay, any objections?
Your Honor, we'd have no objection to the monetary condition. Your Honor, we would ask that instead of the blanket no contact with the children, we'd ask that there be a no contact except for a except as outlined and allowed through a family court proceedings. I think that would be appropriate at this point in time. I don't believe there is a family court order at this point in time, but if Mr. Johnson elects to move in that position to be allowed to see his children. Thank you.
All right, and any response from the state?
No, I think the court's in the best position to decide given the arguments from both parties.
All right, well, I'm gonna order a signature bond as agreed upon order of no contact director and direct with Michelle A. and BMJ and BRJ, except as allowed by family court orders. They appoint guardian ad litems, they do all sorts of investigation. It is not something that's probably gonna happen right away just because he files. It could be something that's timely while they look into things. But certainly the starting point of a no contact is appropriate given what's alleged in the complaint here. And I'll order that you not possess or consume any alcohol. What about time limits? He has the right to a prelim in 20 days. I think, yeah, that was the.
I think that's correct. So we would change that to Michelle H instead of Michelle A.
Okay, thank you. So just to clarify, I think we had an incorrect last initial. There'd be a no contact director and direct with Michelle H. I think maybe A was the middle initial.
Oh, wait, time limits, Your Honor.
Okay, we are adjourned.
Yep, we're getting out today. Yep.
Thanks for catching that. Yeah, it looks like that's consistent with the PC affidavit. It's a full name.
John, right there?
For the record, in the state of Wisconsin versus John Retchick, it's 25 CM 2976 appearances.
ADA Cecilia DeMarco for the state.
Yeah. Yeah. Yep.
And how do you pronounce your last name? Rizek.
Yep.
John Rizek appears in person and in custody and with attorney Devontae Wyndham. From the State Public Defender's Office, Mr. Rizek is, we're unaware at this time if Mr. Rizek is eligible for public defender services. I've handed him a copy of the public defender sheet. The address on the complaint appears to be correct. At this time, we'll acknowledge receipt of the complaint. We'll waive its formal reading and stand mute to count one.
Okay, so Mr. Rizek, if you need a lawyer after today, you can always apply with the Public Defender's Office. They've given you that info. If you're eligible, they'll get you an attorney at little or no expense to you. If you're caught in the middle, you could apply for a county appointed attorney. I'll make a finding of probable cause and or not guilty plea. I don't think we have a PSA report. State's position on bail.
State's recommending a signature bond. We will ask that as a sole condition, the court set a no contact order with Christian common spelling, last initial F.
Any issue with that?
No.
Okay, we'd have no objection.
Okay, we'll order a signature bond, no contact director and direct with Christian F will be the condition, and we are adjourned.
Thank you. Next to Xavier Long.
On the record in the state of Wisconsin versus Xavier Long, it's 25 CF 2871 appearances.
ADA Cecilia DeMarco for the state.
Xavier Long appears in person and in custody and with attorney Devontae Wyndham from the State Public Defender's Office. Mr. Long was found not eligible for public defender services. I'm handing him a copy of the public defender sheet if he wishes to reapply. The address on the complaint appears to be correct. I'll acknowledge receipt of the complaint and waive its formal reading.
All right, so Mr. Long, if you can't hire an attorney after today, you could reapply with the public defender's office, or you could apply for a county attorney. That's the middle option. The public defender can kind of point you in the right direction to do that if you need that assistance. I'll make a finding of probable cause. We don't have a public safety assessment, state's position on bail.
The state is asking that the court set $1,000 cash bail with the condition that the defendant be prohibited from operating any motor vehicle. It's alleged here that the defendant fled from law enforcement at speeds of up to 120 miles per hour. It's also alleged that deputies had to deploy spike or essentially strips designed to slow down a vehicle that is traveling at high speeds, which then caused him to pull over, and they initiated a high-risk traffic stop. It's also my understanding the defendant does not have a valid driver's license at the moment to begin with, nor did he at the time of this incident. My information is that he had a probationary driver's license that was suspended due to numerous traffic infractions. So based on all that information, I think cash bail is appropriate, and I don't think the defendant should be allowed to drive whatsoever by virtue of his bond conditions.
Great, and Attorney Wyndham.
We'd have no objection to the non-monetary conditions. However, we'd be seeking a signature bond here. Mr. Long currently resides here. He's resided here the entirety of his life. He is currently renting. He is 19 years old. He does have ties to the community with parents and siblings and friends residing within the community. He is currently working within the community as well. He's currently working at FedEx. He's been working with them for the last 2 months. In addition to all of that, I do believe that the purpose of cash bail is to adequately ensure an individual's appearance in court. There's brain science that states that, flee and eludes are more impulsivity, and when individuals have time to think in regards to whether or not to show up to court, they tend to make the opposite decision of the impulsive decision when being pulled over by police. In regards to the circumstances here, I do believe that a signature bond would adequately ensure his appearance in court. We've had no acknowledgement of any missed court appearances. And so for all those reasons, I do believe that signature bond is appropriate at this time. Thank you.
All right, well, I guess I'm not familiar with the science or research in regards to the flee and elude and being more impulsive and not meaning that somebody wouldn't show up in court. I know when they did this study for the public safety assessment, that wasn't something that was factored in, but as I understand, a lot of those charges were more broad-based categories. They didn't break them all out by single charge, and this maybe got lumped in with other charges like OARs or OWIs and other traffic-related offenses. I did a little research one day when I had some extra time, and I got through about 25 cases that were flee and eludes that have gone from initial appearance to disposition. At least 8 people, many of whom had posted cash bail out of that 25, failed to show up in court. And I took a look at it because anecdotally, it seems like I do see a fair number of people in court who are on flee and eludes after the initial appearance. But I wasn't certain whether that was because they picked up new charges or didn't show up in court. Obviously, that's a very small sample size, but to me, that's consistent with just the nature of the behavior. You're fleeing, eluding because you're afraid of consequences, and now you're looking at a felony and the potential of prison. If convicted and maxed out here, that suggests that you might want to not show up for that as well. I think it's a cash bail case. I'm going to set $1,000 cash bail. I'll order that you not operate a motor vehicle. That's certainly an appropriate condition given the alleged driving behavior and the prior driving history and the probationary license. You would have the right to a preliminary hearing in the next 10 days. Should we schedule that?
Yes.
Okay, we are adjourned.
Next is Damari Richardson.
We'll go on the record in the state of Wisconsin versus Damari Richardson. That's 25 CM 2985 appearances.
ADA Cecilia DeMarco for the state.
Damari Richardson appears in person and in custody and with Attorney Devontae Wyndham from the State Public Defender's Office. Mr. Richardson is eligible for public defender services. Your Honor, we'd acknowledge receipt of the complaint. We'll waive its formal reading, standing mute to count one. And the best address for Mr. Richardson to receive mail is 519 Bappin, B-A-P-I.
DAPIN.
Mm-hmm.
All right.
But I also get my mail at Aberg, the job center, Aberg Avenue.
Okay, which address do you prefer to
I
have
prefer
court
Aberg
notices sent? Okay,
And my stepmom said she want me to start using her address, so she can get no trouble.
okay, we can do that. I'll make a finding of probable cause, so get a not guilty plea entered to the charge. There's a public safety assessment report. It recommends a signature bond. What's the state's position on bail?
We're willing to echo that recommendation. We will ask that as conditions, the defendant be banned from the UW Hospital East location unless legitimately seeking medical care, and that he be ordered to have no contact with the victim, Heidi, common spelling, last initial H, unless that is also by virtue of him seeking legitimate medical care.
We'd have no objection.
Okay, so order a signature bond, conditions will be banned from UW Hospital East unless you're there for legitimate medical care, and that you have no contact direct or indirect with Heidi H unless you're again getting legitimate medical care. And we'll be adjourned. Might be it. Woo.